So good afternoon, everyone from bright and sunny London this afternoon. My name is Krishnendu Mukherjee, and I'm a barrister and an Indian advocate and co-chair of the Business and Human Rights Group here at Doughty Street Chambers. I would like to welcome you all to our latest of our Doughty Street Chambers Business and Human Rights Roundtables, the purpose of which is to promote the corporate duty to respect human and environmental rights and provide remedies and leverage where violations are found. The term unprecedented has been used, perhaps overused in recent times, but even the most ardent climate change denier cannot fail to see the increasing erratic weather patterns, and most importantly, the effects of those on the most vulnerable across our planet. COP26 aims to get global agreement on how global warming should be mitigated and how we should adapt to its consequences. Whatever its outcomes, one thing is certain, that unless business is required to play their part in addressing these issues, there can ultimately be no real progress. It is to an examination of what this role is that we dedicate this roundtable, with presentations from experts on the role of business on the biggest human rights challenge that we face as human beings. As is usual practice now, the microphone and the chat function and the video options for all participants are disabled, and all your questions and comments should be put in the Q&A function and will be answered as we go along. We are very proud of having three expert speakers today, the first of which is Surya Deva, who is a professor at the Makeri Law School in Sydney and the chair of the UN Working Group on Business and Human Rights. You may also wish to note that he's in the process of drafting the working group's information note, which will be released by the end of October, and a link will be provided in the chat. So please, Surya, you have 10 minutes or so. Thank you.
Thank you very much, Krishnendu. I hope you can hear me. Thank you for the invitation. It's really a great pleasure to join a very distinguished panel of speakers. So in this brief time, I would like to focus on three aspects. I will start with why does climate change matters to businesses. I will advance three regions for that. I will briefly talk about the information note that Krishnendu just now mentioned, because I'm drafting that information note as we go now. And finally, I will talk about some unique or critical challenges that climate change poses to business and human rights field, and potentially what we need to do. And I think I will conclude with that. So let me start with UN Guiding Principles. So as you know, UN Guiding Principles were adopted in June 2011, but they nowhere mention climate change in the principles or the commentary of the any of the principles, right? So does it mean that climate change was not relevant in 2011? Or does it mean that the climate change is not relevant to businesses as part of their responsibility to respect human rights? And I think the answer should be no. I would provide three arguments or regions. Two are normative, and the third is more economic. My first argument is based on linkages. I think it's fairly well established and accepted now that the climate change is going to impact, or is already impacting, in fact, each and every human right: civil, political, social, economic, and cultural human right. Which basically means that if businesses ignore climate harm or climate change considerations, they cannot effectively discharge their responsibility to respect human rights. That's the first point. Second is, if we look at the commentary to Principle 12, it talks about additional standards may be relevant. And I think I will argue that the climate change related standards, some of which are also evolving subsequent to the UN Guiding Principles adoption. Let's Paris Agreement was 2015, SDG 13 again later, after the adoption of UN Guiding Principles. So it can be argued that additional standards may evolve And because UN guiding principles are based on social expectations, these expectations may change and evolve as well, right? So we need to interpret guiding principles in a dynamic manner. And keeping that in mind, we can argue that climate change standards are relevant as part of the additional standards, even if they are not mentioned in the UN guiding principles. My third point, which is not normative, but is practical or economic, is that the destiny of business and the Mother Earth is linked. Businesses will not be able to survive if the climate is going to destroy us and the planet. And I think that is going to be a huge disruption to the existing business models. And I think that's where it is absolutely vital for businesses to come together and do this. Right? Now, let me briefly talk about the information note. So this information note is our initial attempt on the part of the working group to provide some guidance to both states and businesses in relation to climate change, what UNGPs mean for states and businesses. It will try to cover all three pillars of the UN guiding principles, and let me provide you a quick flavor of some of the issues that it may capture. As part of pillar 1, I think policy coherence is absolutely vital. If we have one government ministry trying to protect the environment and trying to mitigate and adapt to climate change crisis, but we have other ministries who are actively promoting fossil fuel, then I think that policy coherence is missing, and then it's not going to work. We can also talk about the policy coherence at the vertical level. So if the trade and investment agreements do not take cognizance of the climate change considerations, then this is not going to work, right? I'm sure you have seen newspaper reports early this year where a German company said that we are going to sue the government of Netherlands. Why? Because the Netherlands has promised that we will phase out all coal-fired electricity plants by 2030, right? So here we're talking about the vertical policy incoherence that is there and the relevance of it. Now, ESG has become a buzzword as human rights due diligence has become. But there is a great risk that this ESG may become a greenwashing tool. And I think that's where it is critical that we understand what ESG means, what is the relationship of ES and G. And perhaps this should be mandatory and the quality of the disclosure should be monitored. Otherwise, this is again going to become tick box, right? The other element of pillar 2, which is going to be quite crucial in my view, is extraterritorial obligations and the collective obligations. Because if states act alone, that itself will not be enough in my view. They need to work together, and they also need to manage the footprint of their businesses overseas, including in their supply chains. Now, let me quickly go to pillar 2. I'm sure Chiara will talk about in detail, so I will not touch too much on that. But I think the two elements that I would like to highlight is that when we talk about human rights due diligence, it should be holistic. So it has to cover all aspects that will capture climate harm as well. But I think the additional point I would like to make is that do we need to change anything in the due diligence processes so that it is better tuned to capture climate harm? And I will stop at that. And of course, the other element in pillar 2, which is quite crucial, is lobbying. Can businesses continue to lobby against government policies which are trying to mitigate and adapt to climate crisis? And at the same time, they claim that they respect human rights. Finally, access to remedy. I think the accountability of both governments and businesses is going to be crucial. But what does it mean for climate change? Of course, there have been some interesting and exciting cases coming out of different jurisdictions. But what does it mean for the victims? What about the past harm? Because climate change is not something that started yesterday. It has been taking place for decades. Who is going to be responsible for that? What about the future impact, right? What about the rights of the future generations? And what about the climate defenders, if they are impacted by the policies of the government or the companies, how to deal with that, right? Now, finally, let me flag some issues that deserve serious attention in my view. First is the transition sufferings. The transition to net zero or a zero carbon economy is not going to impact everyone in the same manner. Some people will suffer more. So we have to ensure that this transition is human rights compatible. And I think states and businesses would have to act to ensure that this happens. The second challenge I see is that there's a lot of discussion and focus on about renewable energy. But renewable energy could also be irresponsible energy because it involves a lot of mining. And mining could be responsible not only in relation to the labor rights issues and child labor, but it could also be in relation to the environmental issues. And what will happen to the life cycle of the battery operated vehicles and cars and solar panels, right? Who will take care of that responsibility, right? So I think those issues are very critical. What about climate finance and the sharing of technologies? Because the due diligence, which Chiara will talk about in detail in relation to climate crisis, is absolutely vital. I think there is nothing to dispute that, but my suggestion is that will not be enough. We would need companies to share the technology. Like COVID crisis is showing us that the companies are not willing to share the technology of vaccines. The TRIPS agreement is still being used, right? I think the climate crisis, in my view, is going to raise a similar challenge. If the developing countries, if the companies in the global south need those technologies and they don't have it and they don't have the resources, who will provide it to them? And will it be obliged that they will have to provide it? Those issues are critical. And of course, the issues about climate finance, who will provide it? I already hinted about the remedial challenges. I think climate change is going to pose some of those unique challenges in terms of causation, attribution, and of course, future generations. Now we are using children to provide a standing to fight for climate change. But what about those who have not even taken birth now? Can someone litigate on their behalf? I think that is a question we should be asking, right? Can Krishnendu, as a trustee of a future generation, litigate against companies? I think those are the questions we should be thinking about, right? Let me conclude with this, that the COP26 is an excellent opportunity to push the agenda on some of the challenges that I'm highlighting. Basically, we need an altogether radical and transformative thinking about how we conceive the very idea of development. Because we are used to a certain model of development, which is based on, let us say, on supply chains, big companies, and a particular lifestyle. Do we need to change this? I think that is the question we should be asking. Thank you very much, Krishnendu. Back to you.
Thank you so much, Surya. Yes, that was a wonderful overview of some of the issues and the challenges that we face from those who are trying to make business more accountable, more forward-thinking in relation to human and environmental rights. And thank you for keeping to the time limit. Our next speaker is Chiara Macchi. She's a lecturer in law at the law group, the University of Wageningen in Holland, in the Netherlands. In the past 2 years, she has led an EU-funded Marie Curie research project focusing on business and human rights in the policies of the EU. And she recently published 3 articles exploring the climate dimension of business and human rights, 2 of which specifically deal with the notion of climate due diligence, which is a phrase that she has coined herself. The focus of her talk today is going to be on the concept of climate due diligence as a necessary dimension of human rights and environmental due diligence. And she's going to give us an overview of how this principle may be enshrined in emerging legislation on mandatory due diligence, particularly at the EU level. So Chiara, over to you. Thank you.
Thank you very much. Good afternoon, everyone, and many thanks to the organizers for the invitation, and thanks to my fellow panelists. I will start this brief talk by presenting my own definition of climate due diligence. So bear with me, and of course, I will welcome any comments and criticism. So first of all, I argue that climate due diligence constitutes a necessary dimension of human rights due diligence As Surya was saying, although the UN Guiding Principles on Business and Human Rights do not explicitly reference the environment or climate change, I believe that a coherent conceptualization of human rights due diligence requires its holistic or dynamic, as Surya said, interpretation in the light of all relevant norms of international law, combining mutually reinforcing principles of international human rights law, environmental law, and climate law. Climate change is recognized as one of the main human rights threats of our time. It was also one of the key issues that led the UN Human Rights Council to affirm for the first time a few days ago that access to healthy and sustainable environment is a universal human right. The human rights impacts of climate change, of course, entail an element of uncertainty in that we don't know exactly when, where, or whom its harmful effects will hit. However, the occurrence of such human rights impacts is virtually certain, and we know that most likely those impacts will be large-scale, wide in scope, and irremediable. Arguably, therefore, a company, especially a company that produces high amounts of greenhouse gas emissions, cannot fully discharge its responsibility under the UN Guiding Principles without assessing and addressing its own contribution or link to climate change. But how do we decline the responsibility of corporations in relation to climate change based on the categories of responsibilities enshrined in the UNGPs, in the UN Guiding Principles? The UNGPs distinguish, broadly speaking, two categories of responsibility. The first one is a strict responsibility of businesses to avoid causing or contributing to adverse human rights impacts. The second one is the company's due diligence responsibility to seek to prevent or mitigate the adverse human rights impacts that are directly linked to its operations, products, or services by its business relationships. Now, let's look at the first scenario. Companies that are contributing to a human rights impact, therefore, whose acts or omissions bear a causal link to such impacts, have a strict responsibility to stop contributing to the impacts and, if needed, address them. As concerns climate change, arguably, some companies' activities produce such a significant amount of emissions that they can be said to be contributing to anthropogenic climate change. This could be the case of the so-called carbon majors, namely those corporations that historically bear the greatest responsibility for human-produced greenhouse gas emissions. A study by CDP and the Climate Accountability Institute looking at the top 100 fossil fuel producers comments that the scale of historical emissions associated with these producers is large enough to have contributed significantly to climate change. It follows, and I'm still quoting, that the actions of these producers over the medium-long term can and should play a pivotal role in the global energy transition. It can be argued that under the UN Guiding Principles, these companies have a strict responsibility to cut their emissions to levels compatible with the Paris Agreement's goals. And this most likely will also require refraining from investing in new fossil fuel projects. This actually resonates with what the District Court of The Hague ruled in the case Milieu Defensi and others versus Shell. The court, interpreting norms of domestic law in the light of the Paris Agreement, of the UNGPs, and of international human rights law, affirmed Shell's obligation of result to cut the group's Scope 1 emission. Now, let's look at the second scenario for a moment. In other cases, a company or investor, such as a bank, for instance, might not be contributing to climate change directly, but they may be linked to it, for instance, by their Scope 3 emission. In the case of investors, for example, they might be linked to high emissions by being minority shareholders of a carbon major. These companies, based on the categories of responsibility of the UN Guiding Principles, would not have a strict responsibility to cut their emissions, but they would have a responsibility to take steps and seek to prevent or mitigate the climate change impacts of their business relationships. And this resonates with what the Netherlands OECD National Contact Point stated in a case involving ING Bank. in which it asked the bank to measure and address its Scope 3 emissions, namely the emissions produced by companies in its lending portfolio. It is also largely consistent, once again, with the Shell's judgment mentioned earlier, as the court in that case affirmed that the company, in addition to the strict obligation to cut its Scope 1 emissions, also had a best efforts or due diligence obligation to reduce its indirect emissions. Now, should states and the EU translate the principle of climate due diligence into a binding requirement, and would it be useful? States are increasingly being targeted through climate change litigation as well, both at the national level and before international human rights bodies. They are being called upon to adopt more ambitious and effective policies to achieve the Paris Agreement's goals, and this will most likely entail stepping up the regulation of business activities as well. The European Union, in particular with its European Green Deal, has the opportunity to play a pivotal role in this respect. As you may know, a directive on mandatory human rights and environmental due diligence should be tabled by the Commission in December. It will be adopted in the framework of the Green Deal and is expected to also include an environmental and climate change dimension. Earlier this year, the European Parliament adopted its own recommendations to the Commission, proposing the text of a directive. And this proposal embraced a broad definition of due diligence, covering not only human rights, but also good governance and the environment, including climate change. Should this broad definition be confirmed in the Commission's proposal, several questions will still remain to be answered, and I can list some of them. First of all, for instance, how do we ensure the climate due diligence, that the climate due diligence obligation, as Surya also mentioned, does not result in a mere box ticking exercise in which companies can get away with under-ambitious due diligence plans? Secondly, how do we differentiate between the responsibility of large transnational corporations and those of small, medium enterprises, provided that the latter will fall under the directive's scope? Third, what about civil liability? The European Parliament's proposal requires states to have in place a system to hold corporations liable when they cause or contribute to human rights impacts. The exercise of due diligence in line with the guiding principles does not automatically absolve a company from liability, but the defendant would bear the burden to prove that it took all due care to avoid the harm in question, or that the harm would have occurred even if all due care had been taken. How would that apply to climate change related impacts that by definition are the result of the acts and omissions of multiple subjects? We will be able, I guess, to say a bit more about some of these issues once the official proposal will be published, and we can also discuss some of them in the Q&A. In any case, concerning the question, can climate due diligence stop climate change? I would answer not on its own, so I agree with Surya. It is not, of course, the silver bullet. Mandatory human rights and environmental legislation, due diligence legislation can be one of the instruments adopted by the state or by the European Union in the context of a polycentric governance system in which all public and private actors play their part. Indeed, the necessary focus on the responsibilities of companies should not overshadow the primary duty of the state to enable the energy transition. As underlined by the Dutch court in the Urgenda case against the state of the Netherlands, the state has the power to control the collective national emission level and is therefore required to take on a high level of care in establishing an adequate and effective statutory and instrumental framework, allowing a transition to a sustainable society. Climate due diligence, as I have interpreted it in this presentation, entails very difficult decisions, radical core business shifts for some major emitters, drastic emission reductions, and so on. It is therefore inconceivable that such changes can happen without a comprehensive and ambitious plan on the part of the state to increase also the availability of alternative energy sources. Thank you very much for now. Looking forward to our discussion.
Well, thank you very much, Chiara. That was very informative. So many thanks for that. I see there's no questions yet or comments yet in the Q&A box. So please feel free to post them, and that'll allow the panelists also to consider them before the end of their contributions. Our final, but by no means least, speaker is Francois Zumere. He is an associate tenant at Doughty Street Chambers, and he's a lawyer who became a diplomat. He's a member of the Paris Court of the Appeal Bar. He practiced as attorney of law for 20 years, as a partner in Jontain Associates. He was elected as a mayor at the young age of 27, and a member of the EU Parliament at the age of 37. He then came back to his first commitment as a fundamental rights activist and joined the Foreign Service, I was going to say Foreign Legion there, Foreign Service in 2008, when he was appointed as France's ambassador at large for human rights. And in this capacity, he's been serving in more than 100 missions around the world, and since 2013 as France's ambassador to the Kingdom of Denmark. He's also been a co-founder of the Alliance of Mayors for the Environment, and he was a director of the Environment and Energy Control Agency. Francois is going to talk today about the French droit de vigilance, and a question whether it's a game changer in relation to climate change and global warming. Even though its scope is wide, it's designed to encompass all kinds of violations of fundamental rights. A large part of the complaints are in relation to environmental and climate issues. And contrary to what was considered when the law was passed, it brings serious concrete consequences, especially on the criminal angle. So Francois, do you want to speak for around 10 minutes?
Thank you very much, and it's a pleasure and a privilege for me to have this opportunity to share some views with you. I'll do that in English, and I have to say that these views inspired by my activities of a lawyer in Paris and in Geneva, of course, but also by my life of a former MEP and a former French ambassador, especially in a moment where we were all committed in the adoption of COP21. And I really congratulate Doughty Street for having organized this seminar. And I share with you, I like anagrams. I don't know if you know anagrams. And I noticed that the anagram of Doughty Street is study together. So I'm glad that we can study together today on this very essential topic. A very essential topic, which is exactly at the hinge between politics, diplomacy, and law. And you asked me to tell a word about, say a word first about the French, as we are talking about due diligence and how the companies could and the enterprises could play a role in the fight against climate change. Of course, I have to put the finger on this new French law, devoir de vigilance, which means duty of diligence, of vigilance. And this law adopted in 2017 was welcomed by the NGO sector as with a deceptive comment, because it had no criminal aspect. A toothless law. But in fact, I'm not of this opinion. I think that this law creates a presumption of knowledge of all the value chain. And this presumption of knowledge of how the services and how the products are manufactured and what is the impact on environment and human rights and biodiversity and of course climate. If you combine this presumption of knowledge from the company with the pre-existing arsenal of laws of manslaughter and involuntary attempts to mankind, it creates a strong criminal threat on the companies. But I think that, and I follow very closely how this law is implemented and which kind of litigation it involves. And I have to say that so far, very few litigation are regarding climate change. Some are in relation with some environmental issues, pollutions. Most are in relation with human rights violations. I mean, general human rights violations, even though one could notice that a large part of the companies that are targeted by the first lawsuit are dealing with energy in the energy sector, especially Total or EDF, Electricity of France. But it doesn't mean that it's in relation with the climate change itself. Those who have tried to litigate for climate change in France, in the French arena, have used another tool than the devoir de vigilance, which is an legal action against the public powers, public authority, in a special jurisdiction, which is the administrative court. In France, you cannot sue the state before a normal court, a civil court. You have to go to a special court named administrative court. It's very, we have two parallel jurisdictions, administrative and for all other cases. And of course, we have some cases for a lack of action, and even very much inspired by the Urgenda case in Netherlands. It's the same legal meaning. One could see as well that some ministers have been sued for criminal action in a criminal lawsuit to the High Court for the lack of proactivity in relation with climate change. I'm not sure it will lead to serious consequences. And I have to say that the tools, I'm a strong promoter of involving the private sector in the human rights and environmental causes. Really, I'm a strong promoter, and amongst the missions I have accomplished, and Christian, thank you for having recalled the number of these missions. There is one which I will never forget. It's the Rana Plaza, of course. So I am absolutely convinced that the business sector is a strong leverage for improvement in terms of human rights, as the foundations and NGO sector is a leverage, as the international institutions were a leverage, and as courageous individuals were the first pioneers in promotion of human rights. So it's like the fourth step of the rocket, now the involvement of the private sector. However, if I do think that the private sector has a role to play, and if I'm sure that the devoir de vigilance law, which is inspiring the new directive, EU directive, which probably will be passed in 2022, so coming year. So I think that it will really inspire a new legal order in all EU. I don't think that this is enough for climate change. It is definitely efficient, and it will bring consequences on human rights. It has already brought, even without litigation, on human rights in some environmental situations, biodiversity and social conditions and wages, of course, as well. But I think that the climate change is too systemic. And I agree with Surya, who said, I hope I am online aligned with your philosophy, your thought. I think that, and this is very much inspired by what I've seen in the preparation of COP21. Climate change is too much systemic to be solved by easy solutions. So I'm not deceptive. I'm not saying that one should not go in that direction or not involved. I'm just saying that one should not be naive. One should not believe that technology will save the world. This is a dangerous idea. One should not believe that due diligence will save the world from climate change as well. There is no, it's systemic. And of course, when it involves companies, it involves customers, clients, and consumers. Not customers, consumers. And it's a kind of, I think, really easy simplification to put the to put the finger on the companies themselves without putting the question of the responsibility of the social body as a whole. And this is why it is difficult. I'm very much inspired in my, I'm thinking loudly, and I'm trying to find analogies, and like you, I'm feeling my way. I'm trying to think what could be efficient. I think that some lessons could be drawn from what happened in the tobacco sector. I have to recall that tobacco is not forbidden. Smoking is generally not forbidden. It's not considered as a drug. It's not like heroin or something like that. It's not even like alcohol. But some companies, as you remember, in America have been sued, and they had to pay huge amount of fines and compensations, not because they have put an illicit product on the market, not at all. Not because their business was in itself prohibited, it was not the case, but because they had unfairly affected the behavior of the consumer and created artificial, deliberately addictions. So I think that maybe one should try to get inspired from this legal meaning to see how one could, in some cases, one could yes, find solutions in the climate change. But just to wrap up, I would say that from the preparation of COP21, I was very much impressed of the presence of an elephant in the room, a great taboo, a word which has not been pronounced and which definitely plays a role in climate change. It's impact of demography and natality on climate change. And it's a taboo because under the pressure of several different religious orders, this question could not be mentioned. And that's important to know, and that the question of natality, of demography out of control, was not in the debate of COP21, because it would have led to a clash and not to a consensus. This is why I do think that from human rights, we shift to environment and climate, but from climate, we come back to human rights. Why? Because I do think, and this will be my last word, I do think that if we want to be to have a strong, massive impact on climate change through a better control of demography, the key is women's rights and girls' education, where they are deprived of this education and control of their body and of their lives. If we make progresses, improvement on the field of women's rights and girls' education, we will have on the midterm, long-term, real consequences on the control of demography and on our control capacity to control global change, climate change. Thank you.
Well, thank you very much, Francois, and that echoes a number of my thoughts on global warming as well, in terms of technology, in terms of systemic change, and also in relation to injustice. The fact that it's the most vulnerable, people who've least contributed to the problem are the most affected. We have a number of questions, and I think your presentation leads very well onto a question by Nicolas Angelet, which is on your Q&A as well. And that question is, how exactly should business and human rights fight the consequences of climate change? Is it just with emission standards, or also with a broader approach, for instance, by fostering the education of women, which may also be the most important through indirect means? And I think that that's also, if we look at the wider challenge of human rights and environmental rights, for instance, some of the issues that I work on in terms of child labor or debt labor, occupational health, all of those issues seem to be much more important, at least in the short term, and certainly to the people involved, than a much more ephemeral concept of global warming, which at least in the global south seems a much more distant threat than what's facing them directly. So maybe I could ask Professor Zumere to come back first on that.
I think thank you, Krishnendu, and thank you for the questions. I believe that we need to take a multi-pronged approach to deal with this climate crisis. I think all three panelists directly or indirectly hinted that, right? So there's no one silver bullet. Francois also mentioned we need a systemic change. And I think the education definitely has a role to play, but I would say it's not literacy, but education, right? So I think there's a difference between literacy and education. And I think we, of course, need to educate girls and women, but I would say we also need to educate every consumer, every investor, every leader, every person who has a capacity to act in a positive or negative manner to contribute to the harm to the climate. Because if we look historically, indigenous peoples have been living on their piece of land for thousands and thousands of years. And they lived in harmony with nature. So I think we perhaps need to go back to that kind of a living. Let me give a very practical example. I grew up in New Delhi, Krishnendu. And when I was going to university, there was hardly any air conditioner in any of the homes in New Delhi. That was 1990s. In 2020 now, fast forward 30 years now, it is very difficult, extremely difficult in the summer of Delhi to have a life without air conditioning. The more air conditioners you use, the more gases and more hot it becomes hotter. So it's a vicious cycle. So we need to think fundamental changes, how we are consuming, how we are living our lives, how we are traveling, how we are running the business. Everything has to be thought again, in my view. I'll stop at this. Thank you.
Chiara? Thank you.
Yes, thanks. In the meantime, I was also having a look at the other questions, and I think broadly, my answer is always that we need to act on several levels. And of course, for instance, there are attempts to join the struggles of indigenous communities in some regions of the world with the struggle for, the preservation of a stable climate, of the environment. Of course, there are many points of contacts with the fight of certain indigenous people for their own cultural identity, for their rights, for their traditions, because they largely coincide with more sustainable lifestyles, with nature conservation, with indeed more sustainable ways of production. The thing is, it's like we are trying as a humanity to take several avenues, and we should do that. And the judiciary is one of the possibilities. I'm looking also at Ekaterina's comments. Promoting climate litigation is one of the avenues. Adopting laws on mandatory due diligence is another one. At the same time, there is also this attempt to shift the responsibility on consumers by saying, you shouldn't buy plastic bottles, or you should eat more plant-based, which of course we should do, we are trying to do, but at the same time, it shouldn't be a way to overshadow the role of states that, in my view, are the only ones who can steer the transition. And they can do so by regulating the several elements of the society, including business. And the judiciary, of course, can help because they can put pressure on governments, on corporations. But is it sustainable to have, to promote a transition that goes on lawsuit after lawsuit? I don't think so. I don't think it's efficient. We need something more systemic, indeed. And in my view, here, really the state, the executive and the legislative must be at the helm. And now it would be too long to address also this aspect, but also as what Surya hinted at, like the counter litigation before arbitral tribunal against states that try to pass certain policies for the reduction of emissions. This also calls for an intervention of the international community on reforming international investment law, as opposed to waiting for an enlightened arbitral panel to finally take into consideration human rights in their decisions.
Thank you.
I will stop it here for now.
Thank you very much, Chiara. Francois, I think the question echoes your own thoughts. Do you want to add anything, or? Okay, all right. Katerina Aristova and Tim Cook-Hurl have put questions concerning the judiciary, which I'll combine as one. And essentially the questions are, what is the role of the judiciary? Should the judiciary be more proactive if the states aren't filling the gap of the law in relation to mitigating and adapting to climate change? Should it be the role of the judiciary? Obviously, I don't think the present UK government would like that to fill that gap. And if they don't, then should steps be taken in relation to sensitizing judges? Should they be better trained? Should they be better educated in order to understand the science behind climate change and the cause and effect of climate change? Or indeed, should specialist courts be considered in order to fill this gap? Do you want to start, Chiara, as you're already there?
Yes, I think I have largely answered Ekaterina's question. Again, yes, climate change as a way to put pressure on governments and companies. It has an enormous role to play also occasionally, and hopefully can result in compensation perhaps for affected communities. So we should definitely try that avenue. As I was saying, we must ensure that climate due diligence does not become a box ticking exercise, and this can only be achieved, in my view, not so much by promoting lawsuit after lawsuit, but by having in place a strong and enforceable legal framework, establishing clear standards, even beyond mandatory human rights due diligence legislation. caps to the emissions of the big polluters, for instance. And in the Shell judgment, I mean, in the Shell lawsuit, Shell tried to argue that they were already complying with their own, let's say, climate change responsibilities because they were in compliance of the EU emission traded system. But the court found that current emissions reduction targets in such system are insufficient to achieve the Paris Agreement, the goals of the Paris Agreement. Therefore, the company's obligations under Dutch law indeed were more extensive, and complying with the ETS was not enough. Now, of course, we cannot expect every time, we cannot wait every time for a court to examine the due diligence strategy of a company and assess whether it is ambitious enough or not. Of course, when it's necessary, you know, it's a good thing to have a judiciary that can assess and rule in favor of the claimants, mandate more ambitious company policies and so on. But we cannot rely solely on that. We need a good, enforceable and ambitious regulatory framework in the first place. And of course, there is also the issue that Tim raises about the difficulty of the judiciary to deal with very complex scientific issues. And it's not only about understanding the science, but sometimes also about choosing the science, because as we have seen in the Shell case, there was a lot of back and forward, you know, a lot of the debate about the parties, which one is the avenue for reduction, which would best respond to the Paris Agreement's goals. And of course, the kind of answer that you give influences the judgment, but what are the relevant documents? Should I look at the IPCC report? Should I look at the Oxford study? There is a lot of, there is a difficulty in understanding the science, and there is a difficulty in, you know, finding a shared scientific basis. In the court in the Shell case was criticized because it did not only rely on the IPCC report, but also on other less politically legitimate sources, for instance. So, of course, the judiciary can be trained, they can become expert in managing these matters, but this is not, again, it is not the ultimate solution.
Thank you, Chiara. Thank you. Francois?
No, I agree on that. I am fully of this opinion as well. And I really have the feeling that it's, on one hand, it's very important to promote these new tools of to make the companies and the enterprises more liable on the value chain. But I think it's an illusion and to believe that a legal procedure could really bring systemic consequences on the question of climate change. One has to acknowledge that this is more a political and diplomatic, but also one have to keep the pressure with very relevant lawsuits, not vague and general, but very precise, putting the finger on misconduct and trying to see as well what legal consequence one could draw from how the consumers are sometimes manipulated by some companies and groups, creating addictions, creating because this is the real basis of economy, creating frustration, addictions, exactly as it was the case in the tobacco sector.
That's very helpful. Thank you. Surya?
Thank you. I just want to add a couple of points very quickly on this question, and probably also try to cover the question which Maria posted in the chat. One is that the role of litigation or role of judiciary, in my view, is strategic. Prevention is crucial. We need to bring a systemic change, but I think we cannot ignore or undermine the role of accountability as well. Accountability of a state and the decision makers, as well as accountability of businesses, because of course we need a framework, we need regulation and policy incentives and disincentives, but what about the companies which are not willing to change, right? What about the companies which are lobbying and bribing government officials not to take decisive actions, right? I think those companies and businesses and even government officials, I mean, they would have to be held accountable. And I think there's a role for courts to be innovative. I think courts have those tools available. So I think that's where the strategic role of the courts is crucial. The question raised by Maria is absolutely critical. And I think I hinted it in terms of transition. The impact is not going to be faced by everyone in the same way. So some communities, children, for instance, they may be disproportionately impacted. Women may also be impacted disproportionately, or migrant workers, or those who have, let us say, living in remote parts of islands somewhere, you know, those people will be harmed more, right? And that's where our responses have to be also take account of those differentiated impacts. And my last point for now is that we need also some kind of collective fund to which companies would be compelled to contribute. So I think the individual remediation is needed, but it's not going to be enough for climate change, in my view. You need to create some kind of collective funds, and companies would have to pay for that without any litigation, perhaps. It could be part of the business model, that you have to pay X percentage of your turnover to this climate change fund. And from that fund, then the money could be used by governments as well as small businesses who don't have resources and new technology to mitigate climate harm. Thank you.
Thank you very much. We said that we'd finish round about the hour, and it's almost that time now, but I think that's a very good way to end, in fact, because as we were talking about, it is absolutely a justice issue, which inevitably involves the transfer of resources, technology, knowledge, expertise from those who have it to those who don't have it, if we're in any way going to mitigate or try and solve this immense issue. So thank you for that, Surya. But to all our speakers, I would like to show a great debt of gratitude for their invaluable contributions, and for all the attendees today for attending and being part of no doubt many discussions that are taking place in the run-up to COP26 and during COP26. But this particular discussion from a business and human rights angle about what businesses can or should be able to do to play their part. And of course, to make any progress on this issue, we need all actors to be on board. And indeed, law is just one aspect, and probably not even the most important aspect in relation to combating global warming. And in that context, Doughty Street Chambers, our chambers, is proud to announce the creation of an environmental justice group. We found that a number of the practitioners were doing environmental justice, and it's important that we share our knowledge and our expertise because of our dedicated team of cross-disciplinary practitioners extending from civil to criminal to regulation and so on. And we hope that in the future, the group and Doughty Street can work with many of you present here today. And finally, the challenge of global warming is a tough ask, but as George Monbiot said in an article of his that I read yesterday, George Monbiot is a journalist who's been campaigning on global warming for decades. He said, catastrophe is not a matter of fate, it's a matter of choice. And on that, I thank you all and wish you a good day. Thank you very much.